and then use that understanding to follow the various topics or to understand the various topics that we are supposed to treat at the Ghana School of Law for civil procedure. If there is any question anyone will have at
Sorry, Counsel, you are muted.
yes. So if there is any question anyone will have during the class, usually when everyone is allowed to ask a question during the discussion, we end up like spending so much time on the questions, and sometimes it can be quite disruptive. So I don't know how we are going to do it, but if possible, you just write your question in the chat. I will look at it at the right time, and then I'll ask. But after the class, I would allow anyone who have a question to put on their mics and then ask whatever question they may have. So let's go straight into it. What is civil procedure? There are so many textbook definitions, but no one is going to ask you what civil procedure is at the exams. So what I want us to do is to attempt to understand what civil procedure is on a very general level. So I think the best illustration I always put out for civil procedure is to go back to your LLB days. Now at LLB, on your final exams, you may have a contract law question that will involve one party writing to the other person responding, and then based on the correspondence exchanged between the parties, you will have to advise one party whether there is a contract at any point in time, whether there was a contract, that's an offer and a corresponding acceptance. But when you do your analysis and you come to a conclusion that there was a contract, your advice usually will be that the innocent party can sue the defaulting party, and then you end there. So it seems that at the LLB level, a lot of the questions we answer or the way we are taught, which is the right thing, is to have a theoretical appreciation of the law and know how to apply the theory to come out with a remedy. And that's why we call that the substantive law. But you realize that by advising your client that he or she has a good case, and so he or she can claim damages for breach of contract, the person does not get damages merely by you giving the advice. So there are certain steps that the person you advised must take, by which that person will translate that potential to receive damages into some tangible reliefs. That steps the person must take, those steps he must take to realize that relief, is what we call procedure. So it is the procedure by which the rights which have been breached produce some tangible reliefs to the innocent party. So that is the idea of procedural law. Procedural law is simply to provide a mechanism by which a person whose right has been infringed upon can take steps to translate his right into some tangible relief. So civil procedure simply refers to those rules that will regulate the parties to the case, the courts, and the lawyers to ensure that a party's claim produces some tangible relief. And so, whatever we are going to discuss today and whatever you will learn or read under civil procedure is one step or one part of a long connected chain of steps that will ensure that the advice you give to your client, that he or she has a good case and that he or she can get damages, that he or she can get some reliefs, that client will now achieve those proposed rights or reliefs in their tangible form. That is how I want you to think about civil procedure. So we'll talk about commencement. Commencement will tell us the rules by which the client you have advised will initiate the steps to translate his rights into tangible reliefs. As the claim against will know that a court action has been commenced against him, for that person to appear before the court. Why? Because it is the appearance of that person before the court that will allow the court to adjudicate on the matter so that your client will have his tangible reliefs. After service, the person will enter appearance. Is how he submits himself to the jurisdiction of the court, that the court can decide the issue or issues between the parties. Then the parties will file their pleadings, which will be the statement of claim, the defense, where necessary, a reply, a counterclaim, defense to counterclaim. All of those pleadings we'll think about are means by which the parties tell their stories. They tell the court the real issues that are to be adjudicated upon. Why is that important? Because it tells the court the real issues between the parties, and that will help the party who brought the case to court to realize those tangible reliefs he's seeking. We will go through that after pleadings. Pleadings will close. The court will set down the case for trial so the court will know the real issues to address to ensure the party's claim leads to those tangible reliefs. The court will then go through the trial process, hear the parties on the strength of their case, and then the court will make a decision, which is the judgment of the court. So basically, everything till we get to enforcement, where the party takes steps to actually now enforce the judgment he has received and receive the tangible reliefs. Every aspect of civil procedure is designed to ensure that the person who claims that his right has been infringed upon will get some tangible reliefs for the injury or injuries he or she has suffered. So what I want you to do is from today, when you pick your civil procedure book, you are not thinking of commencement in isolation. You're not thinking of service in isolation. You're not thinking of interlocutory injunctions in isolation. No, you are asking yourself that it is a long chain of procedure or rules, and all of them are interconnected. They serve one particular overriding purpose: to ensure that the actual claims before the parties are brought before the court, adjudicated upon, and the innocent party actually gets the reliefs he's seeking. Now, with this in mind, every country then will make some rules that will govern the courts and the parties and those who assist the courts in the adjudication of the matter. What these rules are going to do is that it is going to tell the court itself and the parties appearing that this is what is expected of you at this point, and this is what you are supposed to do at this point. The essence is that it will ensure certainty. Each party will know that this is what's expected of me. I have to do A, I have to do B, I have to do C. It will also ensure that the court on its own is able to conduct the litigation in a more effective and efficient manner, so that at every point in time we know the judge, the court is not acting on its own whims, but the court is also being regulated. And so civil procedural rules are not rules that the courts merely enforce. No, they are rules that binds everybody, including the courts, to ensure that there is certainty, the real issues are brought before the court to adjudicate, and to ensure that the parties actually participate in the adjudication of the case. So for us, we have our own rules. Now remember that issues concerning civil procedure or the rules of civil procedure are in a lot of documents or statutory documents. So the main document we use is CI 47 because procedure at the Ghana School of Law is taught. Procedure at the Ghana School of Law is taught focusing on the High Court. The rationale is that the High Court is the court that has jurisdiction in basically all matters. And so a lot of lawyers will spend their time appearing before the High Court. But you know that when we look at the sources of civil procedure, we have to first start with the Constitution. Because the Constitution contains a lot of provisions that are basically procedure rules for specific matters. So an example will be presidential elections. Okay, presidential election disputes, the rules are contained in the Constitution. And so the Constitution is a primary source of civil procedure rules. Now, even beyond that, under the chapter on fundamental human rights, there are provisions on administrative justice, for instance, that tells you that the adjudicator or any person who adjudicates on a matter must do so in an impartial manner. So all of that are rules that also affect civil procedure. So you have to know that procedural rules are also contained in the Constitution. Then we can come to statutes. There are so many statutes that provide the procedure by which certain issues should be addressed. So we can think of the Representation of People's Act, for instance, on how it governs parliamentary election petitions. It's a source of civil procedure rules for election disputes. But it is not in any of the CIs that you usually won't lay your hands on when you are reading or learning your civil procedure. So that is another example. Then we'll come to the CIs. So there is the CI 59 for the district courts. There is the CI 47 as amended for the circuit courts and the high courts. So the CI 47 is applied by the circuit courts and the high courts. Then there is the CI 19, which regulates the Court of Appeal. Then there is the CI 16, which regulates the Supreme Court. So when you think of civil procedure rules, you begin from the highest law of the land, the Constitution, and you can trace down to the rules, that's the CIs. All of these are sources of law for civil procedure. With that at the back of our mind, we also need to know that one major aspect of civil procedure is the jurisdiction of the court. When you pick your CI 47, it doesn't talk about jurisdiction per se. Now, every court is created by law, either the Constitution or a statute. So for the superior courts of this country, they are created by the Constitution. Now, that means that if you want to know the jurisdiction of the courts, you have to look at the Constitution. So the High Court's jurisdiction is provided in the Constitution, the same for the Court of Appeal, the same for the Supreme Court. So you see it reproduced in the Courts Act, for example, but the jurisdiction of the High Court itself derives from the Constitution. And there are the lower courts, which are created by statutes. And so you find the statute that creates these lower courts provide for their jurisdiction. So you look at the Courts Act, you see the jurisdiction of the Circuit Court, the jurisdiction of the District Court, and even the jurisdiction of the judicial councils of the various national or regional House of Chiefs. You see that also in those documents. Okay, so jurisdiction is an important aspect of civil procedure. You need to know that. We'll touch on that as we go ahead. But you always need to know that the jurisdiction of a court is part of civil procedure. And that is why when there is a civil case before a court, a party can raise an issue of jurisdiction, that the court doesn't have jurisdiction. And the party, although may be quoting from the Constitution or a statute, the party is still doing civil procedure before that court. So let's have that in mind. But let's delve into civil procedure proper. Why civil procedure? What is the purpose of civil procedure? Now, to know the purpose of civil procedure, you must look at your rules book. Now, the rules book, the CI 47, which is the main document we are using, codifies judicial decisions from common law on the rationale behind civil procedure. Now, this particular area of civil procedure does two main things. It tells you the objective, that is the purpose of the rules, but it also tells you how civil procedure rules are to be interpreted. Let me take that again. This part of civil procedure, which is where we learn about why we have procedure rules, answers two important questions. And I'm saying this because on the exams, some students get confused. One regular question you see in the past questions will be the examiner asking about either Order 1, Rule 1, 2, asking about the purpose of the civil procedure rules, or in some instances, you see the examiner asking about Order 81 when there is non-compliance. Now, sometimes the question will be framed in a different way. It will ask you what is the objective of the procedure rules, or it will give you a question that will require you to talk about how the rules should be interpreted. However the question is phrased, always remember that what we are discussing now, the purpose, the why of civil procedure, answers these two questions. So when you pick Order 1, Rule 1, Sub-Rule 2, for instance, it tells you the purpose, but it tells you in a way that says the application of civil procedure rules. And it says that these rules will be applied by the High Court and the Circuit Court, except that when it comes to the Circuit Court, it is applied with the slight or the necessary modification, what those who like Latin will call mutatis mutandis. The idea here is that because some of the things CI 47 addresses, some of the things it addresses do not fall within the jurisdiction of the Circuit Court. Although the Circuit Court will apply CI 47, those aspects of the rules will not be applicable to the Circuit Court or cannot be applied by the Circuit Court. And then there are some parts where the Circuit Court will apply with some slight variation. So a typical example will be the rule on enforcement of human rights. You and I know that under the Constitution, under Article 33 of the Constitution, it tells us that the High Court is the court that will have jurisdiction when it comes to the enforcement of fundamental human rights. And when you pick your rules book will go on to tell you the procedure by which a person who is alleging a human rights infringement will appear before the court. Now, because those parts of the rules do not invoke a jurisdiction that the circuit court has, that part of the rules is not applicable or cannot be applied by the circuit court. And that is why Order 1, Rule 1 begins by telling you that the rules will be applied to by the High Court and the circuit court. But when it comes to the circuit court, it will be applied with the necessary modification. Okay. But Rule 1 sub Rule 2 tells us the why of civil procedure, the rationale behind civil procedure. It says that the rules contained in the CI 47 are to be applied to achieve some objectives. One, to achieve speedy and effective justice. Two, avoid delays and unnecessary expense. Three, ensure that all matters in dispute between the parties are completely and effectively addressed or determined. Then four, to prevent multiplicity of suits. Now that means, and to me, this is the most important area of civil procedure. Order 1, Rule 1, Sub Rule 2 is telling you that as you are going through the rules, as you flip your pages in your rules book, every rule you are going to see, that rule is there to ensure that there is speedy and effective justice. It is there to prevent unnecessary delay and expense. It is there to ensure that the issues brought before the court are finally determined and to prevent multiplicity of suits. So you can pick any rule in the rules book. The central reason for that rule in the rules book will be to address one of the four things we have mentioned. It can be even more than that, but at least it will be to address one of the four things we have mentioned. So let's go to a rule like joinder. Let's say joinder of parties. What is the meaning of joinder of parties? Joinder of parties allows the parties to the case to add a person who was not originally a party to the case to it, to ensure that, what is it to do? That the issues before the court are what? Finally determined. So an example will be that if I'm suing Michael, who is a landlord, and I'm suing him for declaration of title to land, I'm claiming I'm the owner. Michael is also claiming he's the owner. Now, while suing Michael, I get to know Michael has leased the property to Esinam. When I'm done suing Michael and the court declares title in my favor, I'll have to bring an action against Esinam, by which the court will grant me an order for possession so I can evict Esinam from the land. This will require two cases, right? But joinder of parties is there to prevent multiplicity of suits, which is one of the four things we mentioned under Order 1, Rule 1, 2. It is also there to ensure that what the issues between the parties are finally determined. Because one of the major issues that will come up between myself and Michael's case might be when or who has possession. To determine who has possession, we will need Esinam's voice in the case. So because Esinam is the one occupying the property now, joining Esinam will help Michael make his case that he is in possession because he has granted a lease to Esinam. So Esinam is on the property because of him. So joinder in this situation will help the court to address the issue completely. So that is one of the reasons for joinder of parties. For instance, in the same way, joinder will also be necessary to prevent unnecessary delay and expense. Because I will commence a case, pay a lawyer, pay the administrative charges, go through litigation. When I'm done, then I go and sue Esinam also in a different case, pay a lawyer, go through all of that. So you will see that for every rule that is found in the rules book, we'll be there to achieve one or more of the objectives mentioned under Order 1, Rule 1, 2. So I always say that when you have an exams question on Order 1, Rule 1, 2, it is a bonus question because immediately you understand the four objectives mentioned under Order 1, Rule 1, 2. Examples to support them are littered throughout the rules book. The explanation I gave, we can do the same for service. We can do the same for substituted service. We can do the same for adjournment. Okay, we can do the same for every provision. And so if you have a question on the exams that asks you to talk about the objectives of the rules, you look at Order 1, Rule 1, 2, and distill the four reasons mentioned there and use other provisions in the rules to support your argument. So if you pick the first objective to ensure speedy and then effective justice, if you can pick any provision in the rules and you realize that those are there to ensure what effective and speedy justice. Think about interlocutory injunctions. Why are interlocutory injunctions important? It is there to maintain the status quo. Why do we need to maintain a status quo? If you don't maintain a status quo, someone will just enjoy a Pyrrhic victory, where the victory he gets at trial, he will not get any substantive enjoyment from that. So injunctions ensure that there is what? Effective justice. So that at the end of the case, the subject matter for which the parties are before the court, the one who wins can enjoy the fruits of what? Of his labor. So you can do that for every provision. Pick the objectives one after the other, and you will get rules to support them. That's the first thing you need to remember. But you see, I mentioned that the rules are not the way Order 1, Rule 1, 2 is couched. It tells you that the rules are there for two things. One is that it tells you the objectives of the rules. The other is that it tells you how the rules are to be interpreted. The interpretation bit is also very important, and it means that when the courts are applying the rules, even if the rules are clear and unambiguous, the court must ask itself, the manner in which I am applying the rules, would it lead to achieving one of the four things mentioned there? So the court must only take an interpretation of the rules that will lead to achieving the four objectives mentioned there. So sometimes you will see that you read a procedure case the judgment of a court or a ruling of a court in a procedure case. And then in case A, the court will interpret or will apply the rules to the left. In case B, the court will apply the rules to the right. And it seems there are some inconsistencies. A lot of times I hear lawyers arguing that there are two different positions of the law at the high court, and then there must be some certainty. Sometimes yes, but sometimes the reason is because the court's primary duty when applying rules of court is to achieve the four objectives mentioned there. So it is the interpretation that will lead the court to achieve those objectives. That is what the court will take. And so you see the courts in the Republic versus the High Court, Koforidia, ex parte, the Eastern Development Corporation, Attorney General, and those line of cases. You see the court saying that the rules of court are a handmaiden and not a mistress. They are there to guide the court. That statement in those line of cases are there to inform you that when the court is applying rules of procedure, the court is not strictly bound by the rules in the sense that the court cannot adopt a different interpretation in case A and a different interpretation in case B. The court can. The guiding light to the court when interpreting rules of procedure is simply the four things mentioned under Order 1, Rule 1, 2, which are that the court should adopt an interpretation that will ensure that there is speedy and effective justice, avoid delay and unnecessary expense, ensure the final determination of the issues, and prevent multiplicity of suits. So let me give you a practical example. In a case, I sue Michael. While the case was ongoing, I bring a motion to the court to help me or to get an order to make an amendment. In that case, the court looked at it and said that no, it won't grant me the amendment. Why? The court thinks that at the stage at which we are, amendment may lead to unnecessary delay. Or the court can say that, look, the amendment will not lead to any effective justice. Why? So when we get to amendment, you realize that one of the things the court looks at when grants an order for amendment is whether or not the amendment you want to make will lead to bringing the right issues before the court for adjudication. So although the court can grant amendment at any stage in time, where the amendment is frivolous, is unnecessary, the court won't grant it. Why? Because in the court's mind, granting the amendment will not allow effective justice. Rather, it will lead to unnecessary delay and expense. And it will also not help the court in the final determination of the case. So sometimes that's how the court thinks about and say that, no, in case A, I won't grant the amendment. But you see that in case B, another judge will look at similar facts and go like, no, this time I'll grant the amendment. Why? Because it will ensure effective justice. So always know that when you are reading Order 1, Rule 1, Sub Rule 2, you are reading about the why. That is the objective of the procedural rules. You are also reading about how the courts will interpret the rules. The court must interpret the rules to achieve those objectives. And that is also the reason why anytime you get a question on Order 1, Rule 1, 2, it will require you to also discuss Order 81. So let's go to Order 81. What does Order 81 say? And what is even the purpose of Order 81? Order 81 is telling you what the court should do when there is non-compliance. Now, under the old procedural rules, the LN 140A, the rules were divided into two. There were those rules that did not go to the roots of the matter. When you breach those rules or when you fail to comply with those rules, the courts can easily grant you an amendment or allow you to make the correction and the case will continue. Why? Because the breach of those rules did not go to the roots of the matter. But there were some other rules which were so fundamental in the estimation of the drafters of the law that breach of those rules go to the roots of the matter. So when you breach those rules, the case may be struck out, or if it is pleadings, you may not be allowed to rely on those pleadings. Okay, so basically, non-compliance with those will affect the process or the case before the court. Now, when CI 47 was being passed, the drafters of the rules ensured that our procedural rules will meet the standards in different jurisdictions, because the English civil procedure rules had grown to the point where it had moved beyond it goes to the root of the matter, it doesn't go to the root of the matter dichotomy. And so Order 81 gave us a clear position on non-compliance with the civil procedure rules. Now, Order 81 is telling us that where at any stage in the procedure, a party fails to comply with the requirements of the rules, the failure to comply will not be treated as an automatic nullity. Okay. And here it is not distinguishing between those that go to the root of the matter and those that do not. No, for all the rules, when you breach any of them, the courts will not start by saying that it goes to the root. No, the courts saying that the rules are saying that it will not amount to an automatic nullity. Now, what that means is this. When I have a case against Esinam, and Esinam alleges that I did not comply with a procedure rule, Esinam will bring a motion to, let's say, strike out my process. But when the court is hearing the motion, the court will not begin with an assumption that there is an automatic nullity. No, or because I not comply, my procedure should be, or my process should be struck out. No. Order 81 is saying that the court must begin from the position that my non-compliance does not amount to an automatic nullity. So what then must the court do? The rules then goes ahead to say that where there is non-compliance, the court must look at the non-compliance and its effect to determine whether it will set aside the procedure, it will set aside the process, either in whole or in part, or it will exercise its discretion to allow an amendment. But why is the court allowing that? The rationale for Order 81 is Order 1, Rule 1, Sub Rule 2. The reason why the rules of procedure are now saying that if there is non-compliance, it does not amount to an automatic nullity is because if you treat as an automatic nullity, and let's say you throw the person's case out, the person will go and commence the case again. The person will refile that process. It will delay the court's time. It will amount to unnecessary expense. And so, why not the court look at the matter and then look at the effect, the extent of the effect on the case before the court, and use that to determine whether it will set aside the process, whether in whole or in part, or it will allow the party to amend the process to comply with the procedure. A lot of times, what I realize is that most students do not get the import of Order 81. The import is very straightforward. Order 81 is saying that no matter the rule of procedure that a person fails to comply with, it does not amount to an automatic nullity. The court must look at the effect of the non-compliance on the matter before it and determine whether it will strike it out or it will allow an amendment. Now, this does not mean that the court will not strike out your process for non-compliance. It can strike it out. What Order 81 is doing, or the new thing Order 81 is introducing, which is different from what was under LN 140A, is that unlike LN 140A, where non-compliance with certain procedural rules will automatically lead to a nullity because it went to the root of the matter, under Order 81, if you don't comply, it won't amount to an automatic nullity. The court must examine the effects of the non-compliance to determine whether it should strike out the process or exercise its discretion to allow an amendment. Okay. But then, there are some procedural rules that if you don't comply with, there is no way the non-compliance can be regularized or corrected by Order 81. So those are the exceptions. Okay, you have gone through law for at least 3 years up till now. So you know that in law, when there is an exception, you don't quote the exception before the general rule. You must have a very good statement of the general rule. Then you would now carve out the exception. So what is the rule for non-compliance under the CI 47? The rule for non-compliance is that the failure to comply with a rule of procedure does not amount to an automatic nullity. In such situations, the court will look at the effect of the non-compliance under the light of Order 1, Rule 1, 2. That's the objectives of the CI 47, to determine whether it will strike out the process or case or it will allow an amendment. That is the general rule. Okay. But then the general rule that non-compliance does not amount to an automatic nullity has some exceptions. So there are some exceptional circumstances where non-compliance will amount to an automatic nullity. There is nothing you can do in those circumstances. And what are they? If you read your ex parte Allgate, it tells you that there are certain instances where non-compliance cannot be cured by Order 81. One of them is breach of the Constitution or breach of a statute. Now remember that at the beginning, I mentioned that certain procedural rules are found in parliamentary enactments, and some are also found in the Constitution. Now, it makes common legal sense that if in the hierarchy of norms, the Constitution and statutes are above rules, then if you don't comply with the Constitution, mere rules cannot be used to cure it, right? And you know your principle of law, where a statute provides a procedure by which something must be done, you must comply with that procedure, and non-compliance will amount to a nullity. This is a clear rule that we know even before we learned civil procedure. So that is why where the procedure by which something must be done is provided by the Constitution or by a statute, If you don't comply with it, there is no way Order 81 can save you. So that is one of the first exceptions. The second is jurisdiction. Again, the jurisdiction of our courts derive from higher norms, the Constitution and statutes. But beyond that, jurisdiction determines the court's power, the legal authorization given to a court to adjudicate specific matters. So when a matter goes before a court that does not have the legal mandate to address the issue, rules of procedure cannot be used to cure it by illegally conferring jurisdiction on that court. And so whenever the alleged non-compliance borders on jurisdiction, then the failure to bring the case before the appropriate court that has jurisdiction amounts to an automatic nullity. So please have that in mind. But then, this is the tricky part of jurisdiction. You see, at law, there is the substantive jurisdiction of the court, which is usually provided for in the statutes and the constitutions. Then there is something or some aspect of the court's jurisdiction, which I will call the procedural jurisdiction for this discussion, okay, just to make it easy to assimilate. This is where you see a procedure provided to invoke the jurisdiction of a court. So you will see certain procedure rules that will say that a party will seek leave of court to do something. Now, when the rules say that you need leave of court to do something, failure to seek leave cannot be cured by Order 81. Why? Because if you fail to seek leave, you have not properly invoked the jurisdiction of the court. And so it is a non-compliance that Order 81 cannot cure. So you have to look at jurisdiction under those two lines. So imagine in the exams, you have a question and it says that a party served the writ on a defendant who was outside the jurisdiction. Here, you realize that to serve on the writ on someone outside the jurisdiction, you must seek leaves, 2 leaves actually, for the issuance of the writ, and then leave for the service of a notice of the writ. Okay, so if the party did not do that, the question will ask you, what will you do in this situation? What you will do is that you come by a motion to set aside the writ if leave was not sought to issue it, because the writ will be defective. But if leave was sought to issue it, but leave was not sought to, let's say, serve a notice of it, you would come by a motion set aside the service of that writ. Here, because leave was not sought, the process is defective. Simply because the court's jurisdiction, the jurisdiction of the court to give the order to serve the notice of the writ was not properly secured. So you have to think of jurisdiction broadly. And then there is a third exception. And that third exception is breach of the rules of natural justice. And these are listed in your CI 47 and or other statutes and the Constitution. So where the rule requires notice to be given, so motions, for example, you must give notice, right? Generally, unless the rules or the exigency of time require ex parte, you must give notice. So if you come by a motion and you don't give notice to the other party, even if the court gives an order in your favor, that order can be set aside at any time, even after judgment. Why? Because you have breached the rules of natural justice, one of the rules that cannot be cured by Order 81. In the same way, if the judge is biased or has an interest in the matter before him and goes ahead to hear the case, you can get the judgment or the order struck out or set aside because it breaches the rules of natural justice. Okay, so you must always have it in mind that now non-compliance with the rules does not amount to an automatic nullity. However, the courts are allowed, as guided by Order 1 Rule 1-2, to determine the effects of the non-compliance and decide whether it will strike out the process or allow an amendment to address or correct the non-compliance, except that when the non-compliance goes to jurisdiction, where it goes to breach of a constitutional or statutory rule or natural justice, those cannot be cured by Order 81. So Order 1 Rule 1-2 and Order 81 must always be read together. And I can tell you, out of 30 questions you have on Order 1 Rule 1-2, it will require you discussing Order 81. For if you have 30 questions, 29 out of them. In the same way, when you have 30 questions on Order 81, 29 will require you discussing Order 1 Rule 1-2. And that's why I say that it is always a bonus. And almost every year, a question on Order 1 Rule 1-2 and Order 81 comes up in the exams. So you have to pay particular attention to that. Okay. So let's assume your client came to you. Your client narrated a story to you. Now, after your client narrated that story to you, your duty as a lawyer is to think about the facts and ask yourself, is there a cause of action? A cause of action must be present or is a condition precedent to invoking the jurisdiction of the court. And here I mean to issuing what? A writ. If you go to the court without a cause of action, your writ will be thrown out. So what then is a cause of action? In Letang versus Cooper, the court defines the cause of action as the fact or the factual circumstance that gives rise to a legal right by one party. So to cause a writ to be issued, you must ask yourself, is there a cause of action? The facts my client narrated to me, when I look at these facts, do I think he has a right that has been breached? If there is a right that has been breached, then you can say that there is a cause of action. If there is no legal right that has been breached, there is no cause of action. So one of the first things you think about is whether or not there is a cause of action. Now, we know what the cause of action is as defined in Layton versus Cooper. It's the factual circumstance that gives right to a legal right for which your client or a party will seek what? A remedy. Okay. So now let's assume there is a cause of action. What is the next thing you would think about? You have to think about the parties involved. Now, what do I mean by this? You are going to court for your client. You want to start a case based on the story or the facts narrated to you by your client. So the first thing you have to ask yourself after cause of action is, who are the parties or who should be the parties to the case? Because sometimes, although your client is the one that's narrated the facts to you, he may not be the appropriate person to sue. Example, it is a family land, a family property. Your client is a mere member of the family. Who must bring the case? It must be the head of family who will be sued on behalf of the family. So although your client is the one that brought the case to you, your client will not be the appropriate plaintiff. So you want to know the parties. Who are the appropriate parties? So you have to look at who the plaintiff is. And when you are done, who should be the defendant? It is possible that your client came to you saying that Mr. A is the one that has done him wrong. When you look at the facts very well, Mr. A was simply an agent for Mr. B, and therefore the case must be brought against Mr. B. So you must look at the facts very well and deduce the appropriate parties. That is the plaintiff and the defendant. Now, when you are done, you also want to ask yourself, which court has jurisdiction? Very important, because as we have noticed from our earlier discussion, non-compliance with jurisdictional rules cannot be cured by Order 81. So if your client comes to you, narrates a fact that you think there is a cause of action, you now know the parties that should be sued, you must ask yourself, which court are we going to? So should it be the circuit court? Should it be the high court? Which court will have jurisdiction? So then you must look at the law that governs jurisdiction and deduce the appropriate court where you will commence your case. Now, after jurisdiction, you must ask yourself whether there are some condition precedents that you must meet before issuing a writ. Now, what do I mean by this? There are some, I'm sure you have seen in the Land Act, some other statutes that talks about the fact that certain issues you must attempt ADR first before you go to court. So those are condition precedents. Okay, so sometimes the particular course of action that your client has will require you meeting some preliminary issues before you can go to the court. So you have to ask yourself, are all of these preliminary issues satisfied? Are there any preliminary issues? And if there are any, has it been satisfied before you proceed to issue your writ? Then there is the issue of venue. Okay, we realize when we discuss venue under Order 3, that for the High Court, for instance, there is only one High Court. Ex parte DAO tells us that, however, we have different divisions and different venues for administrative convenience. So the High Court in Ho is the same as the High Court in Accra. The High Court in Sekondi is the same as the High Court in Tamale. However, for administrative convenience, the same High Court has different places or venues. And so you want to ask yourself, what is the proper venue where I can file my case? We know that if you don't comply with venue is not the same as jurisdiction. If you don't comply with venue, the case will not be struck out. Venue is not one that I'll say cannot be cured by Order 81. The reason is because we have only one High Court. And if the High Court has jurisdiction, any High Court in the country can hear the matter. But venue is important because, remember, let's go back to Order 1, Rule 1, 2. We want to avoid unnecessary delay and unnecessary expense. So if the parties are both living in Accra and you go and file the case in Ho, they have to commute from Accra to Ho every day they go to court. So the court can look at this and say that, you know what, to prevent unnecessary delay and expense, let's transfer the case to the appropriate venue. And that is why venue is important. Okay, and as a lawyer, filing a case in the wrong venue, even if it does not affect your case, it embarrasses your credibility because it's something basic that you should know. So sometimes in the question that you usually see on venue on the exams will be usually the question will be two parties, husband and wife. They entered into the marriage, let's say in Koforidua, and one of them now wants a divorce and wants to file the divorce in Accra. And he or she wants to find out from you whether the case can be filed in Accra or it should be filed in Koforidua. Okay, here, if the matter is going to the High Court, then it means the question is requiring you to discuss venue. Sometimes to be a contract, the party entering into the contract in Tamale, one party is alleging a breach, and he commenced the case in Kumasi. The defendant lives in Tamale, the plaintiff lives in Kumasi. That's why you commence the case there. You are the lawyer for the defendant. What will you do? Okay, so you know that here they are trying to tell you that, well, when the contract was entered into in Tamale, the defendant lives in Tamale, then the case must be heard in Tamale. So it's a venue question, not a jurisdiction question. And sometimes on land, the land in question will be in Kumasi. Both parties live in Accra, so they file the case in Accra. Then the defendant brings the case to you. What will you do about it? Here, they are trying to draw your mind to an issue of venue. But we'll discuss venue in detail when we get there. Okay, so these are some of the considerations you need to have in mind when you are deciding whether or not to go to court. Sometimes you will think about, again, preliminary matters, limitation, okay, or even res judicata. Sometimes the client has already litigated a case before and lost and is bringing it to you. You can't litigate the same case again. Or sometimes it has taken too long and so the case is caught by limitations. You think about all of these things before you decide to go to court. Now, let's assume you have considered all of these and there is no legal impediment. And so you want to go to court. That is when the rules on commencement under Order 2, that is when it comes in. So the whole idea or the whole thing about commencement under the rules is simply to tell you how you, the lawyer, who assess the facts and realize that your client has a good cause of action, you have singled out the court with jurisdiction, you have noted where the proper venue is, you've seen that there are no procedural impediments, you want to go to court now. How do you go about it? So Order 2 gives us the steps you have to take to commence the litigation. Now, this is it. A lot of times students want to chew Order 2. Even the rules, I always advise that you don't need to chew the rules. You have to understand the rules like a story. Okay, so that's what I'll try to do with Order 2. It must be in your mind like a story so that when I meet Michael, I can tell Michael that, oh, Michael, if you want to commence a civil action, you must do A, you must do B, you must do B. Okay, tell it in a form that's a story. You don't have to chew Order 2 specifically. Okay, so let's try and then think about it this way. If I want to commence a case against a defendant for my client, I have to get a form which is called the writ of summons. So there is a form. In the past, when we did not have computers and all of those stuff, the forms, and even still, the forms are sold at the registry. So I'll go to the registry and buy the form. Now that form, called the writ, I'll have to make endorsements on the writ. Okay. So in simple language, I'll have to fill the form. Remember, it's a form. So I have to fill it. So there are spaces provided where I'll provide certain information on the rate. Okay. And immediately you know the reason why those questions or the information is being asked of you. You would know what must be on the rate. So that's on the exams. If you are asked what must be on the rate, you don't have to be trying to remember order 2A, order 2, rule 1. What does it say? No. You just have to know the information you need. Because the purpose of the rate, remember it's called a rate of summons. The purpose of the writ is to summon the defendant to appear before the court. Think of it that way. The purpose of a writ of summons is simply to summon the defendant to appear. And that is why when you pick your writ, it says that you are hereby ordered to appear within 8 days. And failure to do so, a judgment may be entered against you without any recourse, like those things that you see on the rate. Simply, so it tells you that the information that you need on the rate, simply information that will help the defendant, or that will help the court bring the defendant before it. That's why it is derived from the name, a rate of summons. So let's ask ourselves, don't even think about law now. If you are suing someone and want the person to appear before the court, what information will you need to give the court, who is a third party? Think of the court as a messenger, who will have to go and serve the person or notify the person to appear. What information will you give? First, the court must know the name and the address of the defendant, because they will go and serve the defendant at wherever he or she lives. So, the name and the address of the defendant. But you need to know also that if the form gets to the defendant must know who is bringing he or she to the court, right? So you yourself as the plaintiff, your details must also be there. So the first endorsement you make on the writ is the addresses of the parties. So their names and addresses, which will be either their occupational address or their residential address. Remember, you don't need P.O. Box on a writ of summons. It's the person's residential address or their occupational address. So simply, the first thing that must be on the writ will be what? The details, that is the addresses and the names of the parties to the case. First thing. Now, beyond that, if one of the parties is suing or is being sued in their non-personal capacity, so that means they are being sued in a different capacity than their person, you must endorse that capacity on the writ. This also goes without much saying. If I'm suing Michael and I am suing as the head of family, the capacity in which I'm suing must be endorsed on the writ. So it will be Noah Adamtey suing as the head of family for the Adriana Ebusian or Adriana family. Then my address will follow. In the same way, if I'm suing Michael in his capacity as a legal attorney or lawful attorney for someone, I will state Michael Obiri-Adjei as the lawful attorney of Mr. Mensah Equiamwa, that I provide Michael's address. So when you provide the details of the parties, if any of them is suing or is being sued in their representative capacity, you must indicate the capacity in which you are suing the person. Okay. So have that in mind. Now, this will be the details, the endorsements as to the parties, right? Now, if the plaintiff, and please, here, you need to pay particular attention. It confuses a lot of people. I even know people in practice who are still confused by this. If the plaintiff, and here emphasis on the plaintiff, if the plaintiff is not resident in Ghana, he does not need leave of court to issue the writ. The only time the plaintiff will need leave of court to issue the writ is if the defendant, not the plaintiff, the defendant is resident outside Ghana. So if I am in Ghana and I'm suing Michael, who is in the US, I will need leave because the defendant is resident outside Ghana. However, if I am resident in the Netherlands and Michael is a defendant and he resides in Ghana, I don't need leave of court to issue the writ. But the rules tells us that because documents have to be served on me as the plaintiff, then if I am resident outside Ghana, I have to provide an address in Ghana where documents will be served. You don't need leave to use that address. Okay, I don't want to mention other this rule that as at now. So remember that the plaintiff, if he's resident outside Ghana, he does not need leave. All he has to do is provide an address on the writ indicating where documents must be served. But what if the plaintiff is issuing the writ through his lawyer? If the writ is issued by a lawyer, the lawyer must provide his business address on the writ. And from the moment the writ is issued, documents to be served on the plaintiff can be served through his lawyer. Now that means that if I am a plaintiff and I'm resident outside Ghana and I cause a writ to be issued through my lawyer, I can choose not to provide an address in Ghana where documents must be served. Why? Because my lawyer's address in Ghana will satisfy the requirements for me to provide an address in Ghana where documents should be served. Okay, but always remember, where the defendant is resident outside Ghana, you need leave for the issuance of the writ. Okay, but always know that the lawyer's address does not replace the plaintiff's address. Always have that in mind. So that the mere fact that you are suing through your lawyer does not mean that you do not have to provide your address as the plaintiff. If you've seen a writ, which I'm sure everyone here has seen before, you see that on the front page of the writ, there will be the addresses of the parties. Then if you are suing by a lawyer, when you flip the writ first page over, you see that it will have a space that says issued by, then you write lawyer, then you provide the business address of the lawyer. So the lawyer's address does not replace the plaintiff's address. However, when you are sued by a lawyer, the lawyer must provide his address, and service on the lawyer will be deemed service on you. Okay, so have that in mind. Now, these are information about the parties to the case. Okay, so you need to have in your mind, if I have to issue a writ, I must provide the details of the parties, their names, their addresses. If they are being sued or they are suing a representative capacity, I have to state the capacity. If the plaintiff is resident outside Ghana, I have to provide an address where documents will be served in Ghana. If the plaintiff is sued by a lawyer, I have to provide the lawyer's address. So these are things you think about. These are about the parties themselves. Okay. But beyond the details of the parties, there are other information that you must provide on the writ. Remember that the purpose of the writ is that when it is served on the defendant will know who is suing him or her. And the defendant will know what he or she must do or what the case is about. So there is a requirement that you also endorse on your writ a statement in the nature of your claim. Now, a lot of people also get confused here because they confuse the statement in the nature of a claim with the statement of claim. So let me take this opportunity to explain. The statement, when you pick a writ, okay, ordinarily, the writ will have 2 pages. The front page is where the details of the parties will be. When you look at the second page, you see statement of claim written there. Okay. That statement of claim space on the writ is part of the writ. So every writ has a space called statement of claim, or what we usually call the statement in the nature of the claim, or some people call the endorsement. Okay. Now that space is where you provide a brief. That space is where you provide a brief account of the claim you have against the defendant. So you see something like on that space, wherefore the plaintiff claims against the defendant for breach of contract the following: 1, general damages; 2, special damages; 3, it goes on and on. You get that? That is all part of the writ. So after you have filled the details of the parties, you go to fill what we call the statement in the nature of the claim, or the statement of claim, which is part of the writ. And it is just a summary. You just state the claims that you have against the defendant. That's all. But that is different from a statement of claim. When we look at the rules, it says that at the time the plaintiff is filing his writ, he will file the writ together with a statement of claim. That statement of claim, the rules mention that you have to file together with your writ. It's not the statement of claim, which is the second page of the writ. That is the separate document, which is your pleadings as a plaintiff. That is a more elaborate, detailed facts of what has happened between you and the defendant. That will be captured on a separate document. And those 2 documents, that's the writ and the statement of claim, which is the pleadings, those 2 documents will be filed together at the registry of the court. Okay, but let's stay with the writ. So you have filled the details. You now come to the second page where you fill the statement in the nature of the claim. That is your claim that you have against the defendant. You fill it at the second page. Now the rules then tells us that if your claim is for a liquidated demand, then you must make an endorsement on the writ. Okay, if your claim is for a liquidated demand, you must make an endorsement on the writ indicating that should the defendant pay the amount that he or she owes you, there will be what? Stay of proceedings. Not that the case will end. There will be stay of proceedings. So here, we need to know 2 things. What do we mean by a liquidated demand? Now, the courts have told us that when we say a liquidated demand, we simply mean that the claim of the plaintiff is entirely a monetary claim that is already determined or can be easily determined by simple mathematical or arithmetic. Let me put it that way. So an example will be if you gave the defendant money and he or she hasn't paid. If you are suing for a recovery of your money, you gave the defendant 200,000 Ghana cedis, you are claiming 200,000 Ghana cedis. That is a liquidated demand. Why? The amount you are claiming is already known. So the court will not require further evidence to determine or to assess the amount that must be paid to you. That we call a liquidated demand. So the criteria to determine whether or not your claim is a liquidated demand is: one, it must be a monetary claim you are making. You are claiming money from the defendant. Two, the money you are claiming, the amount must already be known such that the court does not need evidence to assess the amount. Okay, and here it can mean that it is a simple sum already known that you are recovering, or even if it includes interest, because the interest can be calculated by simple mathematics or arithmetic, it will still be a liquidated demand. So if the entire case I have against Esinam, for instance, is that Esinam and I entered into a contract. Under that contract, I'll give her 500,000 Ghana cedis and she will supply some goods to me. Okay. If Esinam fails to supply the goods, that's a term under the contract, she will repay my 500,000 Ghana cedis plus 10% interest. If I sue Esinam and my entire claim is that I want a repayment or recovery of my 500,000 and the 10% interest, that is a liquidated demand. Even though the court has to calculate interest, it is a liquidated demand. Why? Because the court does not need extrinsic evidence to assess the interest. The court does not need that. So all that the court will do is that how much should be recovered? The principal, 500,000. Okay, 10% of 500,000. You already know it. So it's a liquidated demand. However, immediately I add general damages to my claim, it ceases to be a liquidated demand. Why? Because damages will require evidence to assess. Sometimes you will see a statement of claim or a rate where the lawyer says that general damages of 500,000 Ghana cedis. The mere fact that you, the lawyer, you have quoted the general damages you are seeking does not make it a liquidated demand, because the court will need evidence to assess the damages. So whenever the claim you are making is purely monetary and the amount is already known, that means the court does not need any evidence to assess it. In those circumstances, we say that the claim is a liquidated demand. And in those circumstances, the law is saying that you have to make an endorsement on the writ, indicating that if the defendant pays the amount either to you, your lawyer, or into court before or at the time of entering appearance, there will be a stay of execution. Okay, you don't need to remember this part, what I'm going to say now. But the rationale is simply that if the person pays the amount, if it's a liquidated claim, the person pays the amount, there is nothing for the court to adjudicate. Okay, there is nothing for the court to adjudicate. But then why is it that there will be stay of proceedings? There will be stay of proceedings because the court would want to assess the facts to ensure that the entire issues between the parties have been resolved by the payment of the money. So there will be stay of proceedings. And then if the money was paid into court, the court would then cause the funds to be released to the plaintiff. If the funds are finally released to the plaintiff, the case will then end. So you need to remember that. Okay. Now, one last thing about addresses is that if you don't know the defendant's address, you know this already, you just simply state the defendant's name and write under that the plaintiff will direct service. Okay. In the olden time, it was an important provision in our rules because a lot of houses in Accra were not numbered, or in Ghana were not numbered, but we knew where people stayed. So direct service means that I will take the bailiff to the defendant's house for the bailiff to serve the defendant. Okay, so now you have your rate. You have provided the details of the parties, their names, their addresses. If there's a capacity issue, that's they are being sued or they are suing in a representative capacity, you have provided that on the rate. You have come to your endorsements. You have made the necessary endorsements. That's the statement, the nature of the claim. You have provided the claim you have against the defendant. If it's a liquidated demand, you have provided that on the document that the defendant pays the amount into court, there will be stay of proceedings. You've done that. You are sued by a lawyer. Your lawyer has provided his or her business address, everything on the document. So everything checks out. Right? What then is the next step? Now, remember I said that you do all of this by buying the forms. Now, a lot of lawyers have the rates on their laptop. So you do that by filling the forms in your office. So now you are done. The mere fact that you have filled the document does not mean you have issued a rate. Okay. So think of a rate in this way. There is the completion stage where you complete or you make the endorsements on the rate. Then there is the filing stage. That's where you file the documents at the court's registry. Then there is the issuance stage. That is where the rates will be issued. And then there is the service stage. That is where the rates will be served. So every rate will go through this cycle before the defendant will enter appearance or before the matter will be properly brought under the jurisdiction of the court. So now, we have done the first step, which is the completion or the endorsement stage. We are done with that. We have looked at our document, or we are junior lawyers in the firm. So we have done that. We have sent it to our senior. Our senior has reviewed it and has sent an email that this is good to go. What do? You have to file the rate. Now, this is where the rules then tells us that to file the rate, you must file the rate together with a statement of claim. So this is where, after you've drafted the rate, you would have also drafted your statement of claim. And then you put the two together, and then you file it at the registry. Now, every rate will inform the defendant that a case has been commenced against him or her. You, the plaintiff, you need a copy. So you see that when lawyers are going to court, they go with their files or their dockets. The docket contains documents filed in the case. When you go to the court also has its docket. So when the case is called, you always see that the clerk will take the file of the case and give it to the judge. That file contains all documents filed in the case. The defendant must also have a file like that containing those documents, which means that at the time you are filing a case, you must have at least 3 copies of the rate and 3 copies of the statement of claim. Why am I saying at least? At least because if there are 14 defendants, then the documents you file will be more than 3, right? Because every defendant, 14 of them, so 14 plus you, the plaintiff, 1, plus the court, 1. So there will be what? 16 copies of both the writ and the statement of claim that you file at the registry. So filing is simply when the plaintiff or the lawyer of the plaintiff or an agent here, which can be the court runner or the clerk, appears at the registry with the writ together with the statement of claim and the appropriate copies, that's the appropriate number of copies, presents it to the registrar. If you do that, you have filed the writ. So if anybody asks you, how do you file a writ? Oh, you file a writ by simply making copies of the writ and your statement of claim. So the copies must be commensurate with the number of plaintiffs, the number of defendants, plus a copy for the court, so the total. And then you file those copies signed by the party or their lawyer, that's if they are seen by a lawyer, file it at the registry of the court. Immediately it leaves your hand and it gets into the hands of the registrar, the documents are filed. Then we have cleared the second stage. When you file a writ, the writ hasn't been issued. So how then is a writ issued? See, when the registrar receives your writ, the registrar will inspect the writ. He will go through it and ensure that all the endorsements are properly done. Everything that must be on the writ are properly endorsed on the writ. When he is done, the registrar will put his seal on the documents. So you see, the registrar will stamp all the documents. And when he's done with the stamping, he will cause an entry to be made in what we call the course book of the court. Now, when the registrar puts his seal on the writ and statement of claim and causes an entry to be made in the course book, the writ is issued. So you see, issuance of a writ is not the same as service. A writ can be issued and it wouldn't have been served. Issuance happens when the writ and statement of claim are filed, the registrar inspects and is satisfied that it complies with the rules, puts his seal on the documents, and causes an entry to be made in the course book. From the moment the entry is made, the date on which the entry was made, and the date on which the seal was placed on the documents, that is the date the writ was issued. So that is what we mean by issuance of a writ. When that is done, we have issued a writ. Now, when the writ is issued, the next step is for the writ to be served. But sometimes people issue writs, and after the issuance of the writ, there may be some changes in the circumstances affecting maybe the defendant or the defendant stays. Or some issues may crop up for which the plaintiff will not be able to serve the writ. And so the rules provide for two ways to address these issues. One is the issuance of concurrent writs, and the other is the renewal of a writ. So let's start with renewal. Every writ is valid for 12 months. Now I know that in the legal space, there is a contention. I just deem it as an argument by lawyers where they are just splitting hairs. I don't see the issue there, but lawyers seem to have an issue to argue about that. And so maybe some of the lecturers will tell you that the rate is not valid for 12 months. It is the service of the rate that is valid for 12 months. Well, whichever side of the argument the person is on, what you need to know is that when a rate is issued, you have 12 months within which you can serve the rate. So that's why the rate, or as some will say, the service of the rate must be done or is valid for what? 12 months. So from the day the rate was issued, remember that's the day the seal was placed, course entry was made. That's when the rate was issued. You have 12 months to serve the rate. Now, if you do not serve the rate within the 12 months, and the 12 months elapse, that rate is deemed expired and it is not valid for service. So have that in mind. Now, if you are not able to serve the rate on the defendant, you would make an ex parte application to the court for an order to renew the rate. And the court will usually grant you the order and it will state the extension it is giving you, but the extension should not exceed 12 months. So the court may give you 12 months more within which you have to serve the rate. Okay. That is what we mean by renewal. So you come by a motion ex parte. Now, why is it ex parte? It is ex parte because at the time you have not served the defendant. That's why you're actually coming for a renewal. So there is no defendant to be placed on notice. Okay, so this is something I always tell the students I teach, that a lot of times, if you want to know whether a motion must be on notice or ex parte, you just have to ask yourself two simple questions. One, is there a defendant in the case? If at the time you are seeking the motion, you are seeking the order, there is no defendant in the case, it's ex parte. Two is if it affects the defendant or someone's interest. There are certain instances where there will be a defendant in the case, but because it doesn't affect the defendant in any way, it must also be ex parte. So if you're able to ask yourself these two questions, the answer you give to yourself will determine whether the motion must be on notice or ex parte. So you have to think about that. I know sometimes you want to chew the motion that must be ex parte and the motion that must be on notice. I think it's unnecessary. Just know that in this situation, you must file a motion. So in the exams, I have to draft a motion. Okay. Now, this motion I'm drafting, is there a defendant in the case? Oh, there's no defendant. Okay. Then it must be ex parte. Okay. Sometimes there's a defendant. Ask yourself, well, there's a defendant here, but would this motion affect the defendant? No. So it must be ex parte. Oh, yes, to affect the defendant, then it must be on notice. You have to ask yourself these questions when you forgot whether it must be on notice or ex parte. But here, because there is no defendant in the case, the renewal order you are seeking must be ex parte. And like almost every application or motion, it must be supported by what? An affidavit. Okay, we'll talk about motions and affidavits later, but it must be supported by an affidavit. Okay, and then the court will grant the order, extend the validity of the rate for it to be served. So that is about duration and renewal. Then there is something we call concurrent rates. Now, concurrent rates are rates that are issued after the plaintiff has actually issued the original rate. But after the issuance of the original rate, there has been some significant change such that the plaintiff would want another rate which will indicate those changes and allow either the original rate or the concurrent rate to be served on the defendant. It's a very tricky thing. And over the years when I have taught students, I've seen some of the lecturers, not all of them, some of them explain the concurrent rates in a way that is not actually what the rules contemplates. What the rules contemplate on concurrent rates is simple. So let me give you an example. Michael is resident outside the country. He's in the US. So I sued Michael, right? And the address of Michael is the US. So I applied for leave to issue the rate. When I was granted, I applied for leave to serve a notice of the rate. That was also granted. So I've gone through the right processes. A notice of the rate has been sent to the US to be served on Michael. However, right after I caused the rate to be issued, that's the original rate, Michael came to Ghana. Okay. Or I've heard that Michael has now moved to maybe Uganda. It may not even be permanent. Michael is maybe going to do a job for 6 months there. So I would want to serve the same rate on Michael. But this time, I want to serve the same rate, but with the address, the new address of Michael in Uganda. So I'll apply to the court for a concurrent rate. The concurrent rate will have every detail as the original rate, except the changes that I need to be able to serve the concurrent rate. And here, it will be the new address of Michael in Uganda. So the simple understanding of concurrent rates, as you see under Order 2 Rule 8, is that you use that concurrent rate to address a change in capacity or a change in address affecting the defendant or even the plaintiff without going through the long process of buying a form, making endorsements, filing it, and getting it issued again. With this, you simply come by an application to seek the order to issue one or more concurrent rates. And when it is granted, that rate will be marked concurrent to indicate that there is an original rate and this one is concurrent to it. Either of them can be served on the defendant, and service of either of them is good service. Now, where there is a concurrent rate, if you are not able to serve either the concurrent rate or the original within 12 months, and so the original expires, an order that renews the original rate will automatically renew the concurrent rate. Okay, so please have that in mind. Now, when you are done with this, you are done with commencement. So commencement is simply the story you tell your client that, oh, so this is what we are going to do. I'll need to go to the court and purchase the rate, which is like a form. Okay, and then I'll enter your name and then your address. And since you are the head of family, I'll state that you are the head of family on the rate. Then I'll enter Mrs. Ekuyamanse's name because she is going to be the defendant. I'll provide the name and then the address you gave me. That's where she stays. I'll provide that also on the address. And since you are using me as a lawyer, I'll also provide my business address on the rate. And from that moment when it is served, notice when documents are served on me, it will be that it has been served on you. Okay. Then, because this case is for a liquidated demand, I'll also write on it that If they pay the amount to you or me or into court, there will be what? Stay of proceedings. Okay. Now, when I'm done, you have to give me transportation because I'll have to go to the registry to go and file it. All that will happen there is that the documents that I'm filling as the rate and another document called the statement of claim, which I'll draft, I'll put the two together, make copies of them, send it to the registry. The registrar will inspect it. If it is good and good to go, he will put a stamp on it and make an entry in the course book. And then when that is done, the registrar will give the documents to the bailiffs of the court to go and serve on Mrs. Ikuyamansa. That is what we mean by commencement of proceedings. So immediately you do your endorsement or complete the writ, you file the writ and the statement of claim at the registry. It is good so the registrar issues the writ. From that moment, the case has commenced. Because by issuing the writ, you have said that the court now has jurisdiction over you. And from that moment, the case has commenced. And that is why you can come by motions before that same court. The court can now hear your motions because it has jurisdiction over you in the substantive case. Okay, so please have that in mind. Okay, so now that we are done with commencement, ordinarily in the rules, you go to venue under order 3. But no, in the proper sequence of procedure, after issuance of the rate, the next thing should be what? It should be service. Okay, so that will be the last topic we will discuss for today. Actually, we are supposed to end at 8. Okay, but I will just cover service and then we will finish for today and then we'll continue some other time. If you have questions, then I will look at the questions before we end. So let's look at service. Now, here too, it is a story. You are not the person supposed to serve, neither your client. The courts have people who are called bailiffs. Now, generally, there are 2 categories of persons who serve court documents: the bailiffs and the registered process servers. Now, a bailiff is an employee of the court and is employed to serve court processes. So they are part of the judicial service or the judicial system in this situation. But a process server is a private person, okay, who has a contract with the judiciary, and here the courts, under which they are paid, and the service they render is service of documents. So court documents can be served by the bailiff or by the process server, but usually, if it is an originating document, the first document will be served by the bailiffs. So an originating document will be a writ, or it can be an originating motion on notice, which commences an application, a case that requires an application. So for instance, a human rights action. Okay, human rights actions are by an application, an originating motion on notice, an originating notice of motion. So that is an originating process. Then we have a petition, like a divorce petition, an election petition. It's also an originating motion. So usually those are served by the bailiffs. But other processes, like a motion, all of those stuff, those can be served by a process server. But these are the 2 persons who will do service for the court. So that rate you issued, okay, last week, it will be given to the bailiff. And the bailiff will follow the address you provided to go and serve on the defendant. Now, if it is a rate, the rate and the statement of claim together will be taken by the bailiff, sent to the defendant's address, and it will be served personally on the defendant. Okay. That is basically what happens with a rate. But let me say this. All the processes of a court can be grouped into 2. There are those documents that require personal service, and there are those documents that do not require personal service. Now, a writ and a statement of claim and all other originating processes require personal service. Let me take that again. Documents that are to be served by the courts can be grouped into two. We have one, which is documents that are to be served personally, and the second, documents that do not require personal service. Now, for originating processes like writs, originating motions, and petitions, they require personal service. Okay, so your writ, the one you issued last week, it must be served on the defendant, and it must be served personally. So how do you do personal service? Now, under the rules, under Order 7, personal service is done by the bailiff or the person serving the document going to the defendant or the person to be served. And you leave a duplicate, that is a copy of the document, with the person. So actually, it means handing it over to the person, placing it in the hands of the person. But then we know that the people, when they know you are a bailiff, they won't receive the document. So the rules then goes on to say that where the bailiff gets there and the person to be served is preventing the bailiff from handing over the document to him or her, either using force or threat of force, or they are obstructing the bailiff, personal service will be effected if the bailiff leaves the document as near as possible to the person. Now, this is one of the aspects of service that confuses a lot of people, especially when they are trying to reconcile that with substituted service. So let me explain further. You see here, the document you want to serve, it requires personal service, and you have to leave it in the hand of the person to be served. But the rules are saying that in a situation where the bailiff gets there and the person to be served is obstructing service, is threatening the bailiff, what the bailiff will do is that he or she must leave the document as close to the person to be served as possible or as practicable. And this is different from substituted service, because when you leave it as close to him as possible, it is deemed as personal service. But substituted service is not personal service. Okay, so you need to have that in mind. So if on the exams, you have a question that says that, oh, the document must be served personally, how will you go about serving the person personally? You tell the person, you write in your answer that, oh, to serve a person personally, all you have to do is to hand over an attested copy, a duplicate of the document with the person to be served. You hand it over to them. But if the person is obstructing service, you leave the document as near as possible to the person, and then personal service would have been effected. Okay. Now, there are certain instances where, although a document must be served personally, the circumstances that have prevailed since the issuance of the writ makes it impossible to serve the person personally. And that is when you come by substituted service. So you see, substituted service is an exception that allows you to serve a document that was supposed to be served personally in a non-personal way. So substituted service is not a personal service, but rather it allows you to serve a document that should have been served personally in a non-personal way. Simply because certain matters, certain incidents that have come up have made it impossible to serve the document personally. Okay, and that is why the rules then goes on to tell you how substituted service should be done. So how can substituted service be done? Or under which circumstance will you even get an order for substituted service from the court? And the rule is that if a document must be served personally, okay, and you have tried 3 or more times to serve the person without any success, and it is clear that any further attempt to serve the person personally will lead to undue delay. So here you see Order 1, Rule 1, 2 again coming up. So it tells you that the only reason why the court allows substituted service is to achieve one of the objectives of Order 1, Rule 1, 2. So let's come back to substituted service. So 1, you have tried serving the person 3 or more times without any success. And it is clear that any further attempt to serve the person personally will lead to unnecessary delay. You can apply for an order to serve the person in a non-personal way through substituted service. There's another or a second situation under which a document can be served by substituted service. And here, it is when it is impracticable to serve the person personally. So here, it is not because you have tried 3 or more times. You may not even have tried once, but the nature of the case, it is impracticable to serve the person personally. You can still apply for substituted service. And when you start practicing, you will see this a lot of times. Lawyers will come to court, they have a motion before the court seeking substituted service, but they have not attempted serving the person 3 times. And the court will throw it out. Why? Because most lawyers have not averted their minds to the fact that under Order 7, Rule 6, the grounds under which the court will grant an order for substituted service are 2, and the 2 are disjunctive. They stand on their own. The first ground under which a court will grant substituted service is when you have tried serving the person personally for 3 or more times and there has been no success. And any further attempt will lead to undue delay. In those circumstances, you can apply to the court for substituted service. So let me give you an example. An example is that I'm trying to serve Esinam. Okay. Now, I go to Esinam's house on 1st January. The house is locked. There is no one there. We went on 14th January. The place is locked. There is no one there. Then we went on 31st January. The house is locked. We have tried 3 times. Because the house is always locked when we go there, we can say that, look, any attempt to serve her through that same means will lead to undue delay. So we can come to the court for the court to grant us an order to serve Esinam by substituted service. When the court grants the order, although it's a document that should have been served personally, the court can say that we should serve her through WhatsApp or through Facebook, like the A+ case. The court can say paste it on the notice board in the community. The court can say publish it in the dailies. Then we will serve the person through the publication in the dailies or through sending it through WhatsApp. That's a substituted service because a document that should have been served personally under the order of the court is now being served in an impersonal way. That's one ground. The second ground is where we may not have attempted service at all, but it is impracticable to serve the person personally or to serve a document personally. How would this situation arise? So think of it. I want to serve a Sinam. Okay. Sinam has 18 houses in Accra. 18. I don't know which particular house she will be in at any time T. So how am I going to serve her? If I go to her house at East Legon, there is high probability she will not be there. If I go to her house at Cantonments, there's a high possibility she will not be there. The same for a house at Pokuase, at Tema, all of those places. So I'll come before the court and tell the court that, my lord, looking at the circumstance of the defendant, it is impracticable to serve her personally. We won't be able to do that because which of the houses will we even know she will be in at any particular time? So we pray that the court will grant us an order to serve a Sinam by substituted service. That is the second ground for substituted service. And the court will grant it. And I can serve a Sinam by the means that I ask for from the court, or the court on its own can give the means by which a Sinam should be served. So you need to know, and this is discussed in ex parte combat, you need to know that the grounds for substituted service are two and they are mutually exclusive. You can rely on one, either of them, for the order. Or some instances, you can rely on both. Maybe you've tried 3 or 4 times, you've not had any success, and look, it is impracticable. But know that either of the grounds can sustain an order for substituted service. Now, if a document must be served personally, and for some reason you think it cannot be served personally, and so you want substituted service, you come by a motion ex parte. Why is it ex parte? It's ex parte because there is no defendant in the case. This is the defendant you are seeking an order to serve by substitution, right? So you don't need to give notice to the defendant. If you could give notice to the defendant, you would have served the writ or that other document personally. So here you come by substituted service. So it's a motion ex parte supported by an affidavit. What do you think the affidavit must contain? You don't need to chew this from the rules book. I always say this also. Whenever the document, a motion requires an affidavit, you don't need to chew what must go into the affidavit. It is simple. Every affidavit must contain certain specific information. One will be when the case was commenced. So after you have said all, you have said that the fact that you are speaking to a fact within your personal knowledge and all of that. First, you must say that a case was commenced against the defendant on the 24th, this and that. Then you tell us what has happened within the case, right? So because it's substituted service, you have to tell the court that the bailiffs have attempted service on 3 different days and have not achieved any success. The first was on 1st January, the second was on 14th January, the third on 31st January. You state that. Then now you go to why it is impracticable. Then you state that that's looking at the impossibility in serving the defendant on all the 3 or more days, it is clear that it will be impracticable or impossible to serve the document on the defendant personally, right? And then you tell the court that you have been advised by your counsel and you verily believe same to be true, that this is a good case for which the court will grant an order for substituted service. That is what will go into what? The affidavit. And it's the same for every affidavit. As you go on to read your rules book, and for me, the most important thing I want you to get from this class is that when you go back to read your rules book, this class should have at least granted some understanding on how you approach civil procedure. When you go to your rules book and you're reading every process under the rules where a motion must come with an affidavit, you see that the affidavit will follow the same process. It will be telling when the case was commenced, what has happened in the case, and then telling us why something hasn't been done or something must be done, and then telling us that the court can give the order because your lawyer has told you that. That is basically how it flows always. Okay. So substituted service, you make the application ex parte supported by an affidavit, and then affidavit will indicate or will have exhibits attached. Okay. For ex parte motions, the main documents that must be attached is the affidavit of non-service, because you have not been able to serve. So whenever a bailiff, I'll talk about it generally, whenever the bailiff goes to serve a document, when they come back, they swear an affidavit called an affidavit of service or an affidavit of non-service if they were not able to serve. And then they will make an entry into what we call I forgot the name of the book, but one of the books at the court. I'll remember when I talk about it later. So they will make an entry into that book. Okay. And when you want to prove to the court that a document has been served or has not been served, you just make a search, conduct a search at the registry. The search results will come back telling you the document has been served or has not been served. You add the search results, and if you have the affidavit of service, you add that or non-service to your affidavit, and then you file it with the court. Okay. Yeah, so the name of that book is called Process Book. So the Process Book is the other book in which all processes that have to be served, entries will be made when a document has been served or we've not been able to serve it, the date, the place, the time, all of that will be in the Process Book. Okay, so that is how we serve documents that are to be served personally. Okay, then there are those documents that you don't need to serve personally. Okay, and for those documents, how do you serve them? You can simply leave it at the address of the person. It doesn't need to be handed over to the person. You can leave it at the proper address. You can post it by mail to the person. Okay. And the court may direct some other ways by which the document should be served. Okay. So that is how you do documents that are not required to be served personally. If at the time the document which does not require personal service must be served, you don't know the address of the person, you can serve it at the person's last place of abode, their last place of business, or the usual place of abode or the usual place of business of the person. Okay. Now, if it is a company, you serve it at the company's registered place of business or their office. That's where they maintain as their office. And then if it is a business that is acting by a lawyer, you can serve it on their lawyer. That is also a way to serve documents which are not to be served personally. Now, one other thing I'll talk about here is the fact that the rules also recognize that different people may be served in different ways. Now, what do I mean by that? The way you serve an individual It's not the same way you serve a company. It's not the same way you serve a partnership. It's not the same way you serve a stool. It's not the same way you serve a family. So the rules provide on how some of these specific people should be served. Obviously, for a stool, it can be served on the stool directly, or the secretary of the stool, or the clerk, or the linguist of that stool. Now, if the stool is vacant, there is no chief or king at that particular moment, you can serve it on the caretaker or the regent of the stool. For families, it is served on the head of family. If there is no head of family, you can serve it on any member or a person who is acting as the caretaker of the family's property, okay, or any principal member of the family. Now, if it is a person who is in prison, you can serve it on the person who is in charge of the prison. That is the prison officer. You can serve it on that person. And it is what? Good service. For government officials like ministers, you can serve it on the administrative head of that government ministry or that government department. Okay. Now, the controversial bit is service on companies. So if there is going to be a question on service that will fall on how to serve people, it is likely going to be on service of companies. And this is because the procedure by which companies are served is governed by a statute. It is governed by the Companies Act. If you look at section 290 of the Companies Act, it tells you about how documents are served by the company, and 291 tells you how documents are served on a company. So if you are suing a company or you have a document to serve on a company, section 291 tells us that the document must be left at or must be sent by post to the registered office of the company. You can also send it by official electronic email address of the company. So now you are doing company and commercial practice. You know, when you are filling your forms to register a company, you must write an email address for the company. So if someone conducts a search there and finds that email address as the registered address, they can serve the company through that email address. Or you can also serve the company by a fax to the telephone number used by that company for their fax. Okay. So when you do any of these, you have served on the company. So at the registered office, or by post, or by email, or by fax. But what if you can't find any of these things? Section 291 goes ahead to tell us that if you cannot trace the company's registered office, you can serve on a director. If you can't trace a director, then you can serve on a member. and service on any of these persons will be good or effective service. If any of these people are served, it is deemed what? Good service. But then you can also serve, if you can't find any of these persons, you can serve on the managing director or the company secretary. Now, this means that if you want to serve on the company, you serve at the company's registered office, or you email it to the company, or you fax it to the company. That is the general rule. Okay. If it is impossible to trace the registered address or the email or the fax, then you can serve on a director of the company. If you can't find any director in the country, you can serve it on any member of the company. Now, if you can't find the directors, but you happen to know the managing director or the secretary, you can serve it on any of them and it will be deemed good service. What I want you to get from this is that service of companies are done in accordance with section 290 and 291 of the Act. That's the Companies Act, not the rules. And so you will see that if you pick any civil procedure textbook, there are so many cases against companies that the plaintiff will win and the judgment will be set aside on appeal because there wasn't compliance with the procedure. Now, I always talk about the secretary. You see, the company secretary is not that fair, beautiful lady sitting at the reception of the company. No. A company secretary is the person whose name was registered as the secretary of the company. So if you go to a company and then you sell a document on that young fair lady still at the reception, it is not effective service. It is not proper service. The service is not properly done. So one of the important cases will be the Barclays Bank versus Ghana Cables case. And then there are a series of other cases where the court says that, look, if you go to serve a company and you serve it on someone at the reception, even if the company enters appearance and they participate in the case till the end, they can still set aside the judgment for improper service. So service on the company, because it is statutory, remember, it cannot be cured by Order 81. And so if you are dealing with companies, you must act strictly according to the procedure for service. Okay. So now, let us assume that the document handed over to the bailiff for service, the bailiff has gone out to serve. Now, when the bailiff serves, the bailiff will make endorsements on the document. So if the bailiff went to serve a writ, when the bailiff gets there, whoever the bailiff is handing the document over to, the bailiff will make statements on the document that it was served on this day, at this time, it was given to this person on the document. Then that person will also sign that they have received the document. And then the bailiff will come back to the registry. When the bailiff comes, there are two things the bailiff will do. The bailiff will swear what we call the affidavit of service, or sometimes affidavit of due service. Okay. When the bailiff is done, the bailiff will make an entry into the process book. The entry will include the place, the day, the time, and then the person who received the documents. All of that to be provided there. Now, the affidavit of service and the entries in the process book, they are prima facie evidence of good service. Let me take that again. The entries in the process book and the affidavit of service sworn to by the bailiff are prima facie evidence of due or good service. Okay. Now, in your law of evidence, you have learned that whenever a statute or a law says prima facie, it means it is a rebuttable presumption. Now, that means that the entries in the process book and the affidavit of service, although they are presumed to be true, a person can challenge service even if the bailiff has sworn to an affidavit of service and an entry has been made in the process book. And that's what happened in the Barclays Bank and Ghana Cables case. So the court said that where there is an affidavit of service and there are entries in the process book, but a defendant still challenges service, that the defendant is alleged that there hasn't been proper service, the court cannot simply rely on the affidavit of service or the entry and then push aside the defendant's allegation. The court must investigate to properly ascertain whether or not there has been service. And that is the court tacitly saying that it is possible that there may be an affidavit of service and entries in the process book, but there wouldn't have been good service. And a clear example is service on a company, where the guy went and then served Madam Agnes, the lady sitting at the reception. The bailiff will come back and swear to an affidavit that it has been properly served. The bailiff will cause an entry to be made in the process book of due service, but there wouldn't have been proper service. So the court is saying that where there is no service, where there is an affidavit of service and entry, but the defendant is still challenging service, the court must investigate the matter and arrive at its own conclusion whether or not there was proper service. Now, why is this important? Because until the documents are properly served on the defendant, the court does not have jurisdiction on the defendant. And that is why in the Ghana Cables case again, even on appeal, the court said that if the company was not properly served, even if they participated and judgment was given, they can still set aside the judgment on appeal because the court did not have jurisdiction over them since there was no proper service. And again, if you read Ganda versus Ganda, the court tells you that it is only when the writ and the extent of claim are properly served on the defendant that the defendant comes within the jurisdiction of the court. So service is very important. So sometimes you see a question on the exams, how do you prove service? Okay, so you prove service by relying on the affidavit of service sworn to by the bailiff or the process server who served the document and the entries made in the process book. Okay, when you have the affidavit and the entries, they are indicative of service. So anytime you are asked to prove service, or anytime you have to prove service, as you see when you are reading the rules, for example, when we get to judgment in default of appearance, the rules will tell you that apart from where it's a liquidated claim, where it's an unliquidated claim, where it is for recovery of possession of land, and then where it is debting you, for all other circumstances, you would file an affidavit of service, and the case will continue as if the defendant has entered appearance. That affidavit of service mentioned there is how you prove that you have served the document on the defendant. And you do that by causing a search to be conducted and then asking the court to furnish you with copies of the affidavit of service. Okay, and then you attach it to your affidavit that you are filing to the court, that to prove that you have served the defendant and so the case can continue. You attach it to the affidavit and then you file it. Okay, so whenever in the exam you are asked to how you prove service, they are simply asking you that how do you show that the defendant or another person has been served? You do that as a plaintiff or as a defendant who wants to prove that a document has been served. You do that by conducting a search, and where the search turns out that the defendant has been served, you make request for the affidavit of service sworn by the bailiff or the process server and entries in the process book. Those entries will help you prove service. But then remember that those entries are prima facie evidence of service. And so they only raise a rebuttable presumption. And the courts are saying that when someone challenges service, even when there is entries in the process book and there is an affidavit of service, the court must still investigate the matter and come to its own conclusion whether or not there is proper service. Okay. So I think the other thing we can talk about will be okay, I think how you compute time for service. Okay, so when a document is served and you are counting time, the day on which a document is served is also counted. So, for instance, when a defendant is served with the writ, the defendant must enter appearance within 8 days. The first day is the day the document was served on the defendant, unless the rules specifically uses the language like maybe 3 clear days or 4 clear days. That is why you don't count the date of service. But aside that, all other documents, all other service, when you are counting, you add the day on which the document was actually served. Okay. However, when a document is served at a time or on a day when the courts are not working, if you are computing the time, you will start from the next business day of the court. Okay, so let me give an example. A document was supposed to be served, but the day the bailiff was able to serve that document, the courts were not working. The courts had closed for business. For those instances, the first day will start from the next day the court will sit. Why is this important? You see, the rationale here is that if you are served today, if you want to respond to the document by you also serving your response, if you want to do it today, you should be able to do it because the court is opened, right? But if the day you were served, the court is closed, we can't count that day. For that day, if you wanted to serve on the court, you wouldn't have been able to do it, right? So the courts do not count that day as part of it. And those are documents which are served personally. If a document is to be served personally and the day it was served, the court was not sitting, that day will not be counted as part of the days on which we will take into consideration when computing time. Okay. Now, when it comes to documents which are to be served in an impersonal or a non-personal way, when we are computing the date, if after the document is sent by post, if the document is served by post and it is not returned by the post office as undelivered, so sometimes the post office will not be able to deliver because the address was wrong. So if it is not returned as undelivered, we will start counting or computing the dates from the day on which the person was served, 21 days after the document was posted, not 21 days after it was served. So this is a little tricky. So let's say a document is supposed to be served by post, okay, by the post office. I sent it to the post office on 1st January. Okay. The document did not return as undelivered. If the court wants to know when the document was served, the court will count 21 days from the day I posted a document. The 21st day from the day I posted a document, that will be the day the court will start counting from as the first day the document was served on the person. Okay, so this is important, especially when you are computing time for the defendant or a person served to do something. So sometimes you see the exams question, they will give you dates, and immediately you see an exam question that's giving you dates, you know that they are trying to prick your mind on the time within which something must be done. So let me give you an example. The exam question will say that Esinam's writ was served on Noah on 1st January 2025. Okay. It is 9th January or it is 8th January. Noah has not entered appearance, or at least searches conducted by Esinam shows that on 9th January, Noah has not entered appearance. What will you do? So you have to count. A person who is served has 8 days within which to enter appearance. Okay, so Noah served it on the 1st. So 1st, 2nd, 3rd, 4th, 5th, 6th, 7th. Okay, so on the 8th, Noah should have entered appearance. If Noah had not entered appearance on the 9th, then Esinam can file a motion for judgment in default of appearance. So computation of time is very, very important to know when something ought to be done after a process has been served. Okay, so I think this is a good place to end. The next time we meet and we have to do civil, we can continue from service outside the jurisdiction, and then we proceed from there. But if there is any question, you can ask and then I'll address it before we end. I just hope that at least the discussion was useful and it will help you or to guide you in how you approach civil procedure. But if there is any question, please don't hesitate to ask. Okay.
Yeah,
So
I
I
doubt
presume,
there are questions.
yeah, I presume there is no question. Okay. So thank you to everyone who joined, and especially to Michael for organizing this. I know a lot of time, everyone who comes to the law school is a smart, intelligent person, but sometimes moving from how law is studied at the faculty to how law is studied at the Ghana School of Law that transition can be difficult. So it is very good of you to organize this for your mates to at least benefit from it. So thank you, and then thanks to everyone who joined. And then we'll meet some other time to